Cominciamo la seconda parte.
We're going to start the second part.
Prepared a very simple case. As I actually was speaking with the president in our break, the thing I detest most is that when faced by a client who goes to his lawyer and this lawyer is threatening that he will sue you personally for damages if you don't do what they expect you to do. And this is something which, unfortunately, in our profession, we are continuously being faced with clients which are uncooperative, at times arrogant, and at times they try to obtain through us something which they should not obtain. So this case is between between a Maltese citizen residing in Malta and Clara Vitka, a German citizen residing in Berlin. So they are getting married in Malta in December 2022. So after the coming into force of the matrimonial property regimes regulation. These two spouses, they intend to establish their residence in Berlin. So it's another country. To this effect, they have already purchased an apartment there. So one of the spouses has property in Germany. He has also inherited a movable property in Malta. So he's got property, he is a Maltese national, he's got property in Germany, and he's got property in Malta. Now, Maltese law automatically establishes the patrimonial regime of the community of acquests between all spouses who get married in Malta, irrespective of their nationality, irrespective of what property they have. It is the default patrimonial regime, community of acquests without community of residue. Okay. Now, since these two spouses are getting married in Malta, the patrimonial regime, which is automatically applicable to their marriage, is the community of acquests. So Charles and Clara go to a notary in Malta, and they ask the notary to prepare a marriage contract. Okay, they say that we don't intend to live here. One of us got property here. We intend to live in Germany. We acquire property in Germany, and we want to regulate our affairs. They instruct the notary to draw up a marriage contract whereby they exclude the community of acquests, which is perfectly legal. So both the fiancés before marriage and the spouses after marriage can exclude the automatic applicability of the community of acquests. If it is before marriage, there is no need of court intervention. If the spouses are already married and they want to change the patrimonial regime, there is the family court, which will authorize the spouses to appear before a notary and draw up a deed whereby they exclude the community of acquests and they, for example, adopt the regime of separation of estates. Now, these two spouses, they want to exclude the community of acquests in respect of immovables they own or will own in future in Germany only. So they are insisting that the community of acquests will not be applicable only to assets situated in Germany. And they want their assets in Germany to be regulated by the appropriate institute as established in German law, while the rest of the estate is to be regulated by the community of acquests as established by Maltese law. So this is a case where the parties are insisting with the notary that they want the deed to be drafted in this way. And you might be faced with a very intelligent luminary advocate who will say, who will hold you responsible for damages if you don't do as the clients, as his clients are requesting from the notary. Now, I'm afraid this is a particular case where we are running full foul of the law, because the regulation establishes that there is the unity, the basic principle of the regulation, like in the succession regulation, we have got one deceased and one succession and one law to regulate the estate of the deceased. Even here, you cannot have the principle of cession. You cannot have part of the assets of the marriage being regulated by one law and another part of the estate of the assets of the marriage being regulated by another law. So in this particular case, the notary is bound, I would say, is compelled not to accept, to publish this contract, because it runs counter to the principle of unity as established in the matrimonial regimes regulation. So in this case, the notary has got no option but to refuse to publish this deed. This is a very basic case, which is intended only to underline that the whole asset, the matrimonial property of the spouses should be regulated by one law. And we should be, the notary should be the gatekeeper. We should be the persons who block any attempt to circumvent the law as established by the regulation. Okay. I think it is a very simple case, but personally, I was confronted with a similar case like this one, where the parties insisted that they wanted it. We said, listen, it is our marriage, it is our life, we want to regulate, we wanted to regulate it in this way. And I said, I know, but the law establishes otherwise. So this is how, in my opinion, we should proceed. Thank you.